36 years, and I'm here to impart my wisdom and knowledge about this whole area of the law to those of you who would like to know about it. So I'm talking on a few different lectures on this topic, on different videos, and this will be my third of a series. What I'm talking about today is how do you deal with people who separate and have problems seeing their kids. It's called access problems. Because sometimes people get into these terrible fights in high conflict cases, and one partner or the other partner, whoever has control of the kids or care of the kids, just sometimes makes it very difficult for the access parent to see their child. So, this is a difficult topic to really discuss because everybody's different. Every case is like a snowflake, sort of. So they're all different. But I can tell you there are a few general things I've learned in my 36 years. One of them is that under Canada's Divorce Act, you can't deny a kid a right to see his dad or his mom. It's very difficult to do that. A court will really frown upon it because in almost all cases, there is no neglect, there is no abuse, and even though people try to raise those issues, it just doesn't really happen all that often. So it's usually because people just hate each other's guts, so somebody's trying to prevent you from seeing your kid. So how do you deal with these topics? Well, first thing you do is you don't go to court if you can avoid it. So you hire a competent family law lawyer, someone like me, and what you do is you try to appeal to the good nature that we all have and see if you'll go to mediation. See if they'll find a third party. There are actual licensed mediators in the province of Ontario. I do that as well, but there are social workers, there are psychologists. We have a mediation association, so you can find someone good. And the whole idea is to avoid court because it's unfortunately quite costly and very difficult and takes a lot of time. And the new Divorce Act is really encouraging people amendments to it to try to get you into mediation. It's also called some fancy name like ADR, or Alternative Dispute Resolution. I'm not going to bore you with all that. I'm just saying to you is you can both save a lot of money by going to a mediator. It's that simple. But there are certain situations, very rare, and still very rare, but it still happens, the courts are flooded with these cases, where somebody still won't grant access to a child. They might say various things, make up stories about abuse, might make up stories about a child's having autism and not, getting along with his dad or his mom. But I'm telling you right now, there's a solution to all those problems. And if you have to go to court in Ontario, the first step is for a lawyer, talk to a lawyer, see what your rights are, and you draft an application and you serve it and you file it with the court. This is after all attempts at mediation have failed. And after a short time, it depends on where you are, you can get before a judge. But the judge doesn't make any decision the first time around. The first time around, it's called a conference or a case conference. At these case conferences in Ontario, the judge sort of acts like a mediator. He doesn't make any rulings usually. He makes rulings of that really aren't terribly important, procedural rulings, but nothing that will solve your problem. What he does do, however, is encourage both parties to settle, and he'll tell you what the next judge, if there is a next judge, will likely do in a case like this, like the case where you're being denied access. Now, there are various different solutions. If, in fact, you do have a bad problem with your kid, and there's been a history of some kind that suggests that you and your kid aren't getting along, or perhaps there has been some abuse that you regret, then the court might suggest that you have something called supervised access. So what's supervised access? It means that for a very short period of time, usually a short period of time, maybe just a few weeks or a few months, you would see your child once every week, once maybe twice a week, either with a private supervisor, there are a lot of these private supervisors around in Ontario who you can pay some money to, or the government of Ontario actually has supervised access centers. And you can go to these centers and there's somebody there to watch what you're doing with your child all the time. And actually, if you're being falsely accused of abusing or neglecting your child, it's a wonderful way to prove there's nothing wrong in the relationship between you and your kid. Because there's people there taking notes, and you can take those notes a few months later, take it to a judge and say, you see, I ain't bad at all. Everything's great. And then they'll stop the supervision. So that's one way to think. If in fact there is nothing wrong with you and you just wish to fight this thing, then usually what happens is not a trial, but something called a motion. What's a motion? A motion is an expensive way to get your kid, but unfortunately it's the way to do it. You get your lawyer to draft something like a letter, but it's called an affidavit, and it's a sworn statement or an affirmed statement. It goes before a judge, and the judge, without a trial, can say, you know what? Based on what I see here, that person should see his child. So I once had a case years ago, just a bit about my experience, where a lady was being falsely accused of being a drug addict, and the husband actually went into a garbage can to look for drugs that she threw out. It was a terrible, terrible case. And we proved that he was actually making up the whole story and was creating false bottles and bringing them right to the judge. It was a horrible thing. And we were able to show that this woman was completely innocent and she was in good shape and she had every right to see her child. And the judge not only granted our motion for unsupervised access, but get this, when you win a motion, you're usually entitled to your costs. So all that money that she paid me, she got back about 65% of it from her husband. So this was a short little talk just to let you know what goes on in the access world. In the very worst, I should say one more thing, in the very worst cases, I'd say in about 5% of these cases, they go to trial. And if that happens, God helps you, because it's very expensive. And then you get into things like having to go to third parties like assessment people, assessors, and they interview the kids in the whole world, and they write a report to the court sometimes, or the children's lawyer gets involved. That's a state-run service. And what they do there is they interview the children and they figure out what's best for these kids, and they file a report with the court. And then if all else fails, if nobody can convince both of you to settle at that stage, then you go to a trial. And the trial is only done in maybe 5% of these in all the cases dealing with children's matters. And boy, when that happens, I can't tell you what will happen. But I can tell you this, if you're an access parent that's really being truly denied your right to see your child, and you're telling the truth that there's really not much to worry about when you're with your kid, Canadian law is pretty good, and you'll get to see him or her. Thank you. Hope to see you next time. Click below to subscribe to my channel.